Court does call the case of NKSK Properties LLC versus Ashley Peters.
Good morning, Your Honor. My name is Noel Salo, appearing on behalf of the plaintiff NKSK Properties.
All right. Ashley Peterson, Brian Riggs, Asia Funderburg. They were not present. Would you like to take a default, sir?
Yes, Your Honor, I would.
All right. Raise your right hand.
I have a little problem with my.
Okay,
That's as good as it gets.
that's
as good as it
fair.
gets.
All right, sir. You solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
All right, go ahead, sir.
Your Honor, rent is due and owing in this matter for March of $1,000, April and May at $3,000 each. That's $7,000. There's a water bill in the amount of $1,119. Unfortunately, when the tenant left, she left the property in extremely bad shape with trash, food in the refrigerator, rotten food in the refrigerator, because she had cut the electricity off 2 weeks before she turned the keys over to my clients. There was a $6,350 cleanup bill. $6,350. It required 4 dumpsters to clean up the trash that was left in the house.
Okay.
And I have the bill from Nash and Brothers.
Can I?
Yes, Your Honor. In addition to the trash that was left, there was damage, significant damage to the property in terms of broken windows in front, damaged holes in the drywall. And there was an additional $9,000 bill that was services provided by S3 Paint Solutions.
$9,000 bill?
Yes, Your Honor.
All of this work was done or needs to be done?
All of it was done, Your Honor. It was completed, I think, 2 days ago.
How long were these tenants in the unit?
They moved in August of 25, Your Honor.
Did all this damage?
Your Honor, there were 3 tenants that we know of. When 2 of the tenants moved out, there was another person who was living there who was never, we don't know who that person was. We only know that when the landlord went to collect March rent on March 20th, he answered the door because Ms. Person wasn't there. And I believe, unfortunately, all of these were reasonable and necessary repairs.
Okay.
These were the first tenants in this property that had been, literally, it had just been acquired by the landlord. This is the property itself. It's single family brick structure in Ypsilanti. Carpet had been put in, it had been painted, everything was fresh when they were coming in as the first tenants to the property. And I have miscellaneous photos of the state of the property when they were able to get possession
Okay.
I understand the amounts sound significant, and that's why
Uh, but looking over the bills and them not being here, and they knew this is date and time set for trial, and then a money judgment.
I'm sorry, Your Honor, this is a settlement conference. I had not brought them to be here to explain those bills.
Pardon?
This is a settlement conference, and for that reason, I had not requested the persons who issued those bills.
No, I understand that. I guess I said it. Defendants here.
That's correct. The defendants are not here.
So when I total everything that you've given me, and about 931 away from my jurisdictional limit, I get a total amount of 2469.
That's,
Is that what you think?
yeah.
Okay. So we're going judgment to the plaintiff. Do you have who showed up?
That was Ashley Peterson, Your Honor.
I think Ashley was the only one that showed
She
up.
was the only one who appeared. That's correct.
All right. Judgment to the plaintiff for possession. Said that's necessary, but I have your cost in this case, counsel. I have 130 filing. I have 94.35, $75 attorney fee. It's going to be 35, 9, 12. I have 209.35 in cost. So I will grant a judgment to the plaintiff for $24,069 plus $209.35 in cost, whatever that total out to be. That'll be the redemption amount, as well as a money judgment in that amount as to defendant one only. Right, defendants 2 and 3 were served by attachment, so I can't issue a money judgment. So the money judgment will apply as defendant 1 with a writ to issue in 10 days, should that be necessary. Right. Thank.
Do I need to present an order to the court on this?
Yes, I need a judgment.
Okay.
All right, thank you. Do I dare call this one? I will. Pierce Lake Village Association versus, well, it's listed as tenant, but
Good morning, Your Honor.
good morning.
Morning, Honor. Nick Butchers on behalf of our plaintiff, Pierce Lake.
All right.
Travis Gagnon on behalf of the James E. Heaton Trust and tenant.
All right. And where are we on this?
Good news, Your Honor. We've
Woohoo! No, sorry, that was just visceral.
for the last week and a half, we've been working on terms of the settlement agreement. We've finalized those terms as attorneys today. We just need to circulate them to our clients. They've pretty much agreed to all the terms, just some legalese. So we're
What is the
So well, I passed with the agreement. There's going to be some consideration between owner and association for any past claims. We will be finding pathways forward to try to ensure that help and accommodation are given to the tenant to provide a good environment for everyone who's living there. If that is not too big.
I don't know what that meant.
we're trying to get them evaluated.
Got it. Okay, so I got the sense and initially upon filing, but I had a feeling that there are mental health issues regarding the tenant.
Yes,
Yes.
he, but if I'm correct, he's still in custody as of today with the city or the state or some,
Your Honor, do you mind? Could we approach?
Yes.
yeah.
Okay, on this matter, the record should reflect we had a bench conference in this case, and don't need to go into the details. What I will do is I will adjourn this matter out to July 7th at 9 a.m. And council may appear via Zoom for that proceeding if they so choose. All right,
Thank you, Your Honor.
thank you. Court calls the case Fixing Housing 401k Plan LLC versus Erica and Aaron Ward. Ms. Ward, this is your motion for the court for reconsideration of the calculation. Have you heard anything from the other side? No.
No, and I did also submit a request for my security deposit to him. I haven't heard anything back on that, 7,500. He also did not show up for the circuit course mediation, the circuit court, the other one. And he's just disappeared.
Did
I have nothing further.
from what I understand, so the record's clear, you heard from the plaintiff, well, the owner sent an email asking if the court had considered his previous email. You responded saying you had gotten nothing from him. Is that correct?
Correct. I responded that I did not have an email to respond to.
When you sent that response, did we receive a response at all?
No, sir. I sent that response this morning.
And haven't heard anything. Then I'm gonna make this quick. I think my initial calculations are correct. I looked back, but then you supplied this documentation. I will reconsider the amount. And so I will adjust the damage award from 22,566.04 to 19,057.08. And then I will grant your request. The court finding circumstances would justify that. Consider you had to shut down your equine business. Permitting you to pay $3,176.18 for 6 months. Given that we are on June 2nd, I realize you filed this whenever, I will begin that July 1st, 2026. And then the corresponding final payment would be due 6 months from that date,
And then
December 1st.
and do I send that to him directly,
Then what?
the payment, or do I send it to the court?
When you send stuff, does he receive it?
Well, in the past, I used to do direct deposit. I would go to his bank and just deposit it in his account. I don't know if that account still exists. So I don't know. I would hope I'm sure he is there to get his money at some point.
So how are you intending on sending it?
Well, I would send it to the address that he's given me in the past. I can send it certified to make sure it gets there.
Why don't you do that? Because I'd rather not use the court escrow if we don't have to.
Okay,
Send it to him and keep track of the payments that you send.
okay. So two more just quick questions. That 19,057.08. Now I have to think back whether when I proposed my payment plan to you, I shouldn't have to ask you this, but did I base it off the 1957.08?
I don't know
Well, we just need to make sure that when it gets documented.
what we can do. I've adjusted it to 1905 or $19,057.08.
Yep,
Divide that by 6. Start your payments July 1.
okay. I'm just gonna do that.
All right.
And that will be somewhere documented and sent to me, so,
Well, you prepare an order.
for you to
Yeah.
sign that this is what was decided.
That's what I decided.
Okay,
Prepare an order for the courts.
a motion,
An order.
an order. Okay, I'll have to Google that. Okay, just saying this is what was said. Okay, and the last question,
But the court is ordered. Yes.
there's nothing you can do about my $7,500 that I'm never gonna see from him? Because,
Security.
yeah, you just had that whole conversation. I was like, wait a minute, what about my security deposit? What? You were going to, trying to get theirs for them.
I wasn't doing anything but my job, but
You can't do anything.
security, I can't, you can raise a claim for the security.
With you? Okay,
Certainly will come back here.
He- he-
I don't want to give you legal advice, so you may want to talk to someone. The security deposit, certainly there would be circumstances in which either the security deposit or double the security deposit can be deducted from this amount.
that's what I was hoping you could
And-
do, because you get to decide everything.
What?
You told them the one time that you could file the eviction based on law, but the retribution was up to you.
What?
I remember you saying that.
Yeah.
You did say all that. So technically you
That-
could,
Why are you?
you,
Why are you
thank you.
on with her? Right?
You could technically take the $7,500 off of what I owe him, and that is the only way it would be fair, because he is never going to give me a penny. He's a
That's
con artist.
that's not in your, so I'll do this. In your order, indicate that the court will give a credit for the security deposit not returned against this amount.
Perfect.
So what you're gonna do is you're gonna take the 19,000, deduct the security, then divide 6 payments. Okay?
Thank you so much. I appreciate that.
Welcome. Probably the only thing.
Okay.
All right.
Okay,
Folks, I'm gonna take now, I was gonna be 10 minutes, but Ms. Ward took up part of my time. So 15 minutes, just give me 15 minutes and I'll come back
thank you.
and I'll figure out who I'm hearing next. All right, folks? Oh, don't look down. Huh? Oh, I'm sorry. I thought I heard his feelings. I didn't mean to do that. Court is stayed in recess. You can remain, sir. Court does call the case of Silo Farms versus Rosalind Banks.
Good afternoon, Your Honor. Rachel Dornbush, Tower Slav, P78301 on behalf of the plaintiff.
Ms. Banks, you want to state your name for me?
Rosalind L. Banks.
All right. Had the pleasure of talking to both parties in this case. There is a resolution of the claim that Ms. Banks will be paying the South Farm $600 even. All right. When can that be paid? You know?
It is.
Okay. All right. So let me do this. I'm going to, you'll be paying by check, right? Or are you gonna? Okay. So what's my 2 weeks? Oh. It's Friday 19th. No, we don't have the 19th. We have the 12th. Okay. So what I will do is I'll adjourn this to June 12th, 2026 at. Hello.
Yes, I have to. Pull up what trying to serve farms.
Okay. Is it 2?
2 p.m.
2 p.m. All right. And you, all right. So 6/12 at 2 p.m. The 600 be paid, and as I had indicated, if it's paid, then they'll be submitting a dismissal. All right.
I don't have to return.
You want to come back here and yell at me? Is that what it is? You did, and I shouldn't say that. You not yell at me. Pardon?
Go to prison.
Go- you- Miss Banks, you will never go to prison. There are some people in life that are just blessed. You will not go there. All right. No, you do not have to return. And for this court and this judge, it's been a pleasure dealing with it and getting this resolved for you. Stormbush, always a pleasure. Patty, take care. All right, courts. So I think you are represented by Miss, right? And you guys was Mr. Ham. Got it. And that's who I have it back. And so now I'll be dealing with them. All right? Little patience. Right.
We're going to soul food restaurant,
Pardon?
soul food restaurant.
Soul food on Michigan Ave?
Across from Brown Chapel.
Yeah, I know which one you're talking about. You're going? Right now? You just did that. You just did that to make me angry, didn't you? Okay. Great reason. Court does call the case of Gordon Scott versus Michelle Mathis. Okay, state your names, please.
Scott Gordon.
Michelle Mathis.
Deborah Ripper.
Okay. And ma'am, what is your relationship to the case?
Mother, significant other.
Got it. Okay. This was an eviction case. Where are the parties on this case at this point? What's your position, sir?
It's time for her to move out. It's been time for her to move out.
All right. Ms. Mathis, where are you on this?
I have a place. I just need 45 days. That's it.
You said 45 days.
Yep.
Is it that the other place isn't gonna be ready or what?
Yes. For at least 30. They said like a month, but I'm just giving an extra 2 weeks just in case
All right, they said a month from when?
from Wednesday is what he told me. So it'd probably been guessing the first. So I asked him to move in beginning of the month.
So a month from June
Third,
3rd.
yes.
Who's in the home right now?
Me and my daughter, my youngest.
And are you in the same home?
It's a mother-in-law apartment that's attached to the house.
Describe this for me again. So there's the main house and then there's a mother-in-law suite or,
Correct.
pardon?
I said correct.
Okay,
The original owner had his mother move in and he put a little addition for her bedroom.
got it. And you occupy that portion?
Correct.
Are there common areas that the parties share or no?
Yes.
Yes,
Like what?
the kitchen.
Laundry room.
I'm sorry, what'd you say?
Laundry room too.
Kitchen and laundry room, and those are they between that suite and that, or it's like you go through one part to get to,
You go through a door from the main house,
okay,
and then there's the kitchen, dining room, living room, bedroom, upstairs loft.
got it. Okay, so that's, and at least unlike the last time, your daughter made it through her graduation.
Yes, yes, Your Honor, she did.
From where?
Celine,
Celine?
yeah,
Was that so that was high school graduation?
yeah. No, not a graduation, the ninth grade.
Ninth grade, that's right. Okay.
Mhm.
Okay. So if I time this out, so you're willing to move. We weren't really at that point the last time, so that's some progress. You're willing to move. It really becomes an issue of timing. I'm assuming, Mr. Gordon, you're not willing to give that period in that 30 days.
I mean, we started asking last May.
I know, but I'm here right now.
I know. I would prefer not. It's not like it's prison or jail time, but personally, I've had enough. I've been fairly.
Okay, so here's the practical reality. Today's the 5th, right?
Yes, yes, Your Honor.
If I gave you a standard judgment, which I'd be disinclined to do, but let's say I would give at least an additional week. So if I gave you a judgment today, the move out date is the 15th, right? I would probably give a week, but I'd have to go to the 22nd because there's a holiday in there. So it would be the 22nd. At that point, you'd have to come down to the court, file your order of eviction, right? Pay your $15, file your order of eviction, and then schedule the posting of that by a court officer, okay? But then from that point, let's say you get that all done in one day, and I'm gonna tell you right now, that's not gonna happen in one day. But let's say you can get it all done.
All right, what's the time difference between the two?
You would then, so let's say they posted it that day, they could not even evict effectively until the 25th. Okay.
Okay.
And then and when I say that, let's say she's got stuff in there, you have to schedule somebody to move the stuff out. Schedule and pay for somebody to move the stuff out. And it's got to be taken. I don't know how far you are from the edge of, is it Platte Road? I don't know how far you are from the edge of Platte Road, but everything's got to be taken to the edge of the curb. So you're gonna have to pay somebody to do that, right? So the 25th is ideally the earliest it could happen in any event. Ideally, not ideally, but just based on practice, what I know doing this forever, that you're probably really looking at the 30th before anything happens, because you're looking at a 5-day kind of window. All right. That's a practical reality. Okay.
Excuse me, Your Honor, are we talking June or?
June.
Okay.
June. Yeah, it would occur within this month because we're so early, but just timing out, that's where you're gonna be. And if you Mr. Scott, if you're Gordon, I should- if you think you're frustrated now, you're gonna be more frustrated. Okay. Because it's not gonna be happening like it's not a swift kind of process. It just isn't. And the other, like I said, outside of that, the expense, because you're gonna have to pay to have somebody move it. You can't just take anything that's there off the property. You have to move it to the curb. And then somebody's gonna have to come along and move it from the curb. And so likely you're then gonna get charged by Pittsfield for the moving of that stuff off the curb. Because it's probably not gonna occur on your garbage day or as you arranged by whoever's picking up out there now. Okay, so. I'm gonna tell you what I think, and you guys can tell me what you think, and then I'll just rule. I'm gonna grant them a judgment for possession. Grant him a judgment for possession. I would give till July 3rd, because that's that next Friday over the realistic time frame for a move out. And that would be that date. That's not the 45 days you're looking for. It's 30. If the place isn't ready, you've got to get your stuff out of there. If it's not ready, then you got to figure out where to store it so that they're not paying somebody to move your stuff out to the curb and then paying Pittsfield again.
Correct.
Okay. That's what I'd suggest to the parties, but that puts, if your place, like I said, if your place isn't ready, you gotta get it out there and store it.
Yeah, I could. That would work for me. It's,
And if it doesn't happen, what recourse do I have if we're talking about July 4th and we're still dealing with this?
Then you would, well, that's a good point. Because we'd be coming up on the holiday, but the court. What? We're closed the 3rd. Okay. So. Thank you for bringing that up, because I didn't know if we got the Monday or the Friday. It just keeps switching. So I would actually make it July 1st. And the reason I would make it July 1st, let me just explain this, because then you would have through the whole day, July 1st. If you're not out, then he would have an opportunity to come down to the court to file the order of eviction on the 2nd.
okay,
Right? The court's closed the 3rd, 4th, but would open up Monday. So effectively nothing would happen until Monday, but you'd be able to have your order in at that time. How's
I'm okay with that.
the
Not worth fighting that for a few extra days.
okay, thank you. What you say?
I have work to do.
Yeah, well, yeah, not fighting for a couple extra days, but we'll do that. All right, so I'll grant judgment to the plaintiff for possession. There's no redemption amount, no money judgment. I'm gonna do this no tribal issue after a hearing. And the writ date is extended to July 1st, 2020. Well, actually, it's gonna be July 1st, 2026. Okay? Any questions?
No,
No? So
Mm-mm.
you understand what you have to do. You gotta have your stuff out of there by then. All right? You'll have to, you can do it on the 2nd or you can do it on the 6th, either way, however you want to do it, but I gave you that day, so
Thank you.
worked up and want to do it, you can do it that day. All right, there'll be somebody down here to take your paperwork and your money. We'll always take your money. You need to fill out a judgment form for my signature. So that reflects this. So you'll have to go to the front counter and get a judgment, fill it out, and make sure that the clerks get it down to me. Okay?
Do that when we walk out, right?
Yep, you can do it right now.
Thank you.
You can get the judgment form. You'll have to fill out the top part and everything, and then if any, once you fill it out, if anything's missing that I can fill in, I'll just take care of it.
Thank you.
All right. Thank you, folks. All right. You guys take care.
thank
All right.
you.
And tell your daughter congratulations.
Thank you. My other one's about to have a baby.
Uh-oh.
Week.
A what?
In a week.
My first great grandchild.
You said what? Your first great grandchild? You're not old enough to be a great grandmother, and you're not old enough to be a grandmother. I don't know. I don't know what you guys are talking about. All right. You guys take care.
In this wild landlord-tenant session, Judge J. Cedric Simpson navigated confusing property management changes, massive unpaid rent claims, and emotional tenant stories. He adjourned cases for further investigation while keeping a sense of humor amid the chaos. These hearings reveal the real human struggles behind eviction battles and the importance of clear records. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.